So let's review. Tort law, good. Wrongdoing, bad. Tort law is good because it lets us hold wrongdoers accountable. Wrongdoers are often wealthy, powerful, well-connected, profit-making corporations that have strong ties to legislative leaders and other political leaders. So, raise your hand if you're really surprised that there's been a decades-long effort to weaken tort law and limit accountability and keep people out of court. Right. No one is surprised because there has, in fact, been a decades-long effort to weaken tort law, keep injured people out of court, limit the power of juries to do justice. That has been and is an ongoing struggle. We have the nation's leading expert on this issue here today to speak about it. Joanne Doroshow is the founder and executive director of the Center for Justice and Democracy. She's an adjunct professor at New York Law School, where she teaches civil justice and national advocacy. The Center for Justice and Democracy is the only national consumer organization in the country exclusively dedicated to protecting our system of civil justice. She is tireless, brilliant, hardworking, just a fantastic person to lead this fight. Ladies and gentlemen, Joanne Doroshow.
Wow, thank you. So this is the second conference in less than a week where I've been almost, well, more or less the wrap-up speakers. Well, I know Ralph's following me, so not exactly last, but I know what it is to look out onto a kind of a tired audience, so I really, especially you students, so I really appreciate you sticking it out. And yeah, there are countless threats, looming threats to the civil justice system. There's also a little bit of good news. So what I want to do is just talk a little bit about some trends, both good and bad. I'm not going to cover everything, but if you do have questions, please just contact me. Our website is centerjd.org, the Center for Justice and Democracy, and we have lots of materials there if you have questions about anything. Okay, so let's start at the top, because I think any presentation about the civil justice system and its threats has to start there, and that would be with Mr. Trump. And it's not like Donald Trump doesn't believe in the civil justice system. If he or his companies have been wronged in some way. In fact, before the election, there were some articles about the fact that I think he and his companies had filed something like 1,900 lawsuits in those 20 years before his 2016. But you know, to Trump, the civil justice system is just another expensive plaything for him. He doesn't think anybody else really should have those rights. So since being elected, and particularly the first year or two, he and his administration have actually very much under the radar destroyed a lot of legal rights. Particularly affecting workers, consumers, investors, farmers, students, even Me Too survivors. And we're keeping a running scorecard of this on our website. We call it Trump's Civil Justice Scorecard. And we can't list everything, and I'm certainly not going to list everything here today. Here are a few highlights. Trump issued an executive order. You know, Lynn talked about the difficulty of filing sexual assault and harassment claims against contractors. So when he took office, he issued an executive order that took away the legal rights of assault and harassment discrimination survivors to sue federal contractors, and essentially allowing them to be forced into arbitration. He signed the law to repeal a very important consumer financial protection rule that had allowed cheated, defrauded consumers to bring class action lawsuits against banks and lenders. His U.S. Department of Agriculture made it more difficult for independent farmers like poultry growers to file lawsuits against big agriculture. His Department of Labor allowed negligent financial services advisors and companies to force retirement investors into forced arbitration systems and prevent them from filing class action lawsuits. His Labor Department also withdrew an Obama-era guidance document that made it easier for employees and federal and state governments to sue companies for misclassifying workers as contractors rather than employees, and that has a lot of impact on people's rights to go to court. His Department of Education has moved to prevent students defrauded by for-profit colleges, that's like Trump University, from suing in court or joining with others in class actions. His Centers for Medicare and Medicaid Services moved to strip the legal rights of abused and neglected nursing home patients, forcing them also into arbitration systems. And then when the U.S. House in 2017 passed legislation to strip injured patients of their legal rights, this is medical malpractice that we heard a little bit about today, but also nursing home victims and some drug injury victims. This bill would also overrule state laws, preempt state laws, and limit the power of local juries to award compensation in cases. So when that bill passed in March of 2017, Trump issued a statement of administration policy supporting that bill. That followed, you probably didn't hear this in his first State of the Union, but we did. He actually mentioned support for this legislation in his first State of the Union. And fortunately, the bill died in the Senate, but every executive White House budget that he has issued has indicated support for this legislation. So let's talk a little bit more about this issue of forced arbitration and class actions and Trump and the Supreme Court. Now, you know, we have a big problem with this issue of forced arbitration. Now, arbitration, well, Lynn was telling me earlier today that she makes herself available to be an arbitrator in arbitration cases, but companies don't pick people like Lynn. They pick people that they think are going to rule for them all the time, and that's what happens in arbitration. And at the most extreme, these are private, secret administrative systems, private systems, essentially, where, you know, at the extreme, the arbitrator may not have any legal training, their process has no real rules, they may issue a decision that is contrary to law, or they don't have to issue a written opinion at all. It may be legally incorrect, yet enforceable by the full weight of the law, very limited appeal rights, and it all happens in secret, so there's no legal precedent to show other companies what they should or shouldn't be doing, and to control any kind of future conduct. The real problem with these clauses, which you find in every online transaction, if you know, nobody reads these things, right? You just sort of click agree to terms of service, or it's in your credit card and bank contracts, it's in employment contracts, it's just in a range of different kinds of contracts now. But the most significant impact of these clauses is that the claims get dropped altogether. Nobody goes through this process. And as a corollary, these clauses also have these class action waivers or class action bans. And this is so critical because when a company breaks the law and harms a large number of people, it's very, very difficult and expensive often for an individual to bring a claim by themselves. So class actions allow them to join with everybody else and gain access to the courts that way. It's also much more efficient to do cases that way, because then you don't have to, you know, there's not a lot of different lawsuits filed. But in 2011 and then again in 2013, the U.S. Supreme Court invoked a very obscure law, the Federal Arbitration Act, which was passed in the mid-1920s to facilitate voluntary arbitration between businesses. But this U.S. Supreme Court said that law proved that Congress intended arbitration to be the preferred way, basically, to settle claims, and that's what Congress intended, and found no problem with companies writing these clauses as unfairly as they liked, or forcing consumers into them by sticking them in these contracts that you all agree to, and also preventing class actions to be filed against companies that break the law. So that was 2011 and 2013 before Trump. Enter the Trump administration, and you'll remember Senator Whitehouse's reference of an important case that he was keeping an eye on that most people were not aware of, called Epic Systems. This was a major arbitration case that was before the Supreme Court. It concerned class action rights under the 84-year-old National Labor Relations Act. The Obama administration had sided with the workers in that case, but it was before the case was decided. Enter Trump. His Solicitor General switches sides against the employees, an anti-worker brief, and sure enough, the Supreme Court ruled with Trump and against the workers in that case, and ruled that this 84-year-old law that had allowed workers to bring these concerted legal actions for all that time suddenly couldn't do it anymore, and it affected millions and millions of contracts, employment contracts. Now, as Senator Whitehouse indicated, many of these initial decisions were 5-4, very close votes, but the pro-arbitration precedent is now so entrenched in the Supreme Court that Brett Kavanaugh's first written opinion was a unanimous decision that found that this Federal Arbitration Act prevented a court from interfering with an arbitration clause, even if the court found the effort to force arbitration was forced arbitration of the claim was wholly groundless. So what we're faced with is now the only option is for Congress to do something. And fortunately, there's a little bit of good news. Congress is starting to act on this. On September 20th, just very recently, the U.S. House passed the Forced Arbitration Injustice Repeal Act to end the practice of forced arbitration and class action waivers. And there are a lot of people that work very, very hard on this bill. I want to introduce a couple of them to you. One is Remington right here at Public Citizen. Another is Pamela Gilbert, who is in the audience. Raise your hand, Pam. Who is one of the premier consumer rights lobbyists in Washington. So with their help and a lot of other help, this bill passed, very, bipartisan vote. Now it's not going to pass the Senate, or, Trump has already said he would not sign it, but this is a great first step. But it also, as you know, elections have consequences. If the Republicans were to retake the House again, nothing's going to change on forced arbitration, and you're likely going to see new attacks on the civil justice system. In fact, this is exactly what occurred after the 2016 election. You heard reference, or I made reference actually, to the medical malpractice legislation that Trump said he supported. In addition, in February 2017, the U.S. House Judiciary Committee voted and then eventually passed, wrote and then passed, with no legislative hearings at all, a bill called the Fairness and Class Action Litigation Act. This bill would completely rewrite class action law, gut class actions in America, make it almost impossible, like literally impossible to file a class action. And this would fulfill the dream of the corporate lobbyists that they've had since the 1970s to essentially get rid of class actions in America. So it was voted out. This is despite the fact that the bill would cause massive confusion in the courts, completely upend well-established law that had been worked out for decades, not only by the courts, but by Rule 23, the Federal Rules of Civil Procedure. This is the federal rule that deals with class actions. And the intrusion into that rulemaking process was so egregious that even the Judicial Conference's committee and the Advisory Committee on the Federal Rules chaired by Neil Gorsuch, opposed this bill. I mean, that's how bad this bill was. No matter. Bill was then combined with other legislation that limited the rights of asbestos victims, becoming the Fairness in Class Action Litigation and Furthering Asbestos Claims Transparency Act of 2017, passed the House March 9th, 2017, close vote, no bipartisan support, 14 Republicans voted against it. It was sent to the Senate Judiciary Committee, where it fortunately died. But, you know, it did pass the House. And the problem is that, as you've heard throughout the day, many in Congress are beholden to corporate lobby groups, particularly the U.S. Chamber of Commerce, the largest lobby group in the country by far. And they wanted this bill, and given the strength of their lobbying muscle, this is an issue that's probably not going to go away. Okay, let's talk about Trump in California. It's probably hard to overestimate how much Trump hates California. This is a state that leads the nation against a lot of unpopular Trump policies. One of the more under-the-radar issues is meal and rest break laws for truckers and bus drivers. For a couple of decades, California and 20 other states has had a meal and rest break law for commercial drivers. And the whole point is to keep fatigued drivers off the road, and protects them, and it protects you as motorists from highway accidents. But the American Trucking Association and the American Bus Association have both petitioned the Federal Motor Carrier Safety Administration to preempt or overrule this California employment law. And on December 21st, 2018, just a few days before Christmas, this agency granted the trucking industry petition invalidating California's law, so that companies will now be able to violate California's law with no accountability to anyone if they're hurt or killed. So this is hopefully something that when we get a new president in, we can reverse this situation. But it's, you know, this is another indication of where this administration is. There's also been a battle, as you just heard from Mark, about on the privacy issue. California passed a strong privacy law. The U.S. Chamber of Commerce and the tech companies are urging Congress to adopt a federal framework. Why? Because the most effective way for industry to preempt an area and prevent states from doing more is to suddenly agree to subject itself to federal regulation. Now, we understand this bill probably isn't going to happen this term, at least that's what recent articles have indicated, but don't expect this is going to go away either. Okay, let's talk about the states a little bit. I don't know if you've heard of this group called the ALEC, the American Legislative Exchange Council. This is a secretive group of right-wing state lawmakers and lobbyists, and it's run and largely funded by these same corporate big donors like asbestos companies, insurance companies, a lot of powerful interests. So for about 25 years, ALEC has had a division called the Civil Justice Task Force, which is entirely devoted to weakening or eliminating liability for corporations that do bad things. Its work and its members are secret, but some documents have come out lately through the Center for Media and Democracy, and in the civil justice space, for example, they found 71 bills resembling these model ALEC laws models that were introduced in 30 states. All of them make it harder for everyday people to get access to the civil justice system and provide relief to corporations and the industries who wrote these bills. One of the most common is a bill that would deny claims payments to dying asbestos victims. Generally, these bills force the dying victims. You have to understand, if you have been diagnosed with mesothelioma, you only have 4 to 18 months to live. So this is very precious time to get some kind of compensation. But what this bill would do is force these victims to file all these crazy asbestos trust claims before they can even file a case against a defendant company. But it's really all about dragging out the process until the person with mesothelioma dies. That's a common one that we're kind of working against. Another, and this is kind of the last bad trend I want to talk about, is another one of these unfortunate trends, though, is victim compensation funds. I mean, I think we kind of all agree in this room that the courts are probably the best venue to hear claims, to get victims' compensation, and to hold negligent companies accountable when they've harmed people. But there are limited situations where courts just are simply unable to provide relief. The most obvious are these unusual national events like 9/11. 9/11, in that case, Congress set up a compensation fund funded through the federal treasury, and you may have heard, Congress just voted to permanently renew the fund for ground zero workers, first responders who are now sick and dying at really tragic rates. And it would also include people like me who were down there that day, although don't worry, I'm not sick, but at least it would open up the possibility that if you were down there and you did get sick, you would have a compensation fund to go to. That said, however, corporations with plenty of money who are engaged in misconduct, who should be held accountable in court, have also tried to set up these funds that would limit or restrict the victim's right to sue them in court. This is happening, for example, where corporations have been involved in colossal misconduct and they simply don't want to get sued. The BP oil spill is an example where there was a victim compensation fund set up. GM ignition switch scandal was another one recently, or more recently. Under these systems, these disputes are resolved in some kind of administrative system. Right to trial by jury is eliminated, and compensation is going to be typically much less than one would get in litigation. The legal accountability for the companies is gone or very weakened, and they also protect misconduct by hiding information. So just recently, 2 victim compensation funds hit the news. Each raises some of these concerns. One fund was set up by the Catholic Church in Pennsylvania to handle childhood clergy abuse cases, these victim claims. I think Lynn talked earlier about going after third parties in abuse and assault cases, and this is an example. Their church should be really on the hook in some of these cases. And in neighboring states to Pennsylvania, New York, and New Jersey, recently the statute of limitations, which is the law that limits the time limit you have to file a case, those were extended greatly for the victims of childhood sexual abuse, but not so in Pennsylvania. So rather than change the law, they're forcing these victims to go to this kind of fund and beg for compensation. Another fund has been set up to compensate the victims of the Camp Fire. This was the worst wildfire in California history, which you may have read about, killed 85 people, destroyed the town of Paradise, California. This fire was started by Pacific Gas and Electric's equipment. Now, the company is now filed for Chapter 11 bankruptcy. It originally estimated its liabilities for this disaster at $30 billion, but now that it's filed for bankruptcy, according to the plan that it's presenting to the court, the victims would only get $8.4 billion total, insurance companies would get $8.5 billion, and entities would get $1 billion. So this is far less than what PG&E first said it owed. Okay, so now I'm going to switch to a little bit of positive news. People have talked about this concept of tort reform or tort deform, and basically most of these laws happen at the state level because the states are, tort is generally it's a state right. These laws were developed by the states, by common law, by the courts, by state legislators. So those who want to attack tort system rights tend to go to state legislators to do that, and they've had, unfortunately, some success. One of the most common of these tort restrictions is called a cap on damages. most commonly a cap on non-economic damages. These are the types of damages that are more intangible, but they deal with the quality of one's life, permanent disability, blindness, loss of your reproductive system, trauma. These are non-economic damages. And they also discriminate against women, children, and low-income people, seniors, because they tend to value the destruction of somebody's life based on what they would have earned in the marketplace, because those kinds of damages are not capped. So in June of this year, the Kansas Supreme Court ruled that that state's cap on non-economic damages was unconstitutional. This was all the more surprising to us because 7 years ago, that same court upheld the cap on non-economic damages. So it decided to reverse itself, something that had ruled 7 years ago, finding that the decision 7 years ago was wrong, which we of course all thought it was wrong, but the court itself decided it was wrong, and so in 2019. They followed the lead of the Oklahoma Supreme Court, another kind of red state, which struck down that state's cap in April. So you have Kansas and Oklahoma Supreme Courts in both these red states striking down caps on non-economic damages this year. As a result of these two decisions, now less than half the states cap non-economic damages in medical malpractice cases, which is the most common kind of cap you find on the books, and only 9 cap non-economic damages generally. So I would say that the momentum is kind of in the no-cap direction at this point, which is really good news. Another positive development, I mentioned the FAIR Act to ban forced arbitration and class action waivers. There's another area that Congress has made some headway lately, and this is dealing with something called the Ferris Doctrine. The Ferris Doctrine bars active duty service members from suing the government for negligence. It was a doctrine created by the U.S. Supreme Court in 1950. It's a decision that limited the Federal Tort Claims Act, but essentially expanded the immunity of the government in these kinds of cases in ways that Congress never intended. Even Anthony Scalia in 1987 said that Ferris was wrongly decided. But since it's been in place, it has really hurt victims, active duty service members, victims who are victims of sexual assault, toxic poisoning, medical malpractice, and any other non-combat related harm. All these victims have been blocked from any kind of legal recourse in court. And as usual, of course, the Supreme Court said, well, Congress has to fix this. So a number of bills have been introduced over the years to fix Ferris. The current bills address specifically restoring the rights of medical malpractice victims and their families. There's a shocking amount of medical negligence that goes on in military hospitals. So bipartisan legislation, and it's bipartisan, is being considered by both houses to repeal Ferris, at least in medical malpractice cases. So it's really more popular than we've ever seen it. The bill to start tackling Ferris, but obviously it still has a way to go. I think I have about 5 minutes, and I'm just going to save the rest of my time to see whether anybody has any questions about the looming threats or the positive developments. No, I know, it's a long day. Oh, okay, yeah. Oh, if only. This is the problem. The U.S. Supreme Court says basically no, they're valid. And you've agreed to them. You've agreed to them. Yeah. Well, the people that, sure, you should try to embarrass them. Look, there is more opposition and awareness of this problem than we've ever seen before. We had a letter going to the Hill, which was signed with Remington's help and others' help, over 70 organizations, major organizations, including, for example, Googlers against fair arbitration. You may have heard there's a groundswell of organizing that's happening against these clauses, and individual companies have, in response to this pressure, given up on these clauses, at least for sexual harassment cases. It seems like that is sort of the first line that's fallen when it comes to forced arbitration. There's still class action waivers in these contracts, and they're still applying these to you as a customer. But, in addition to Congress, there is the possibility of getting individual companies to be shamed into giving up these clauses, and by all means, shame them. And tell them, that, you're going to make their life very difficult if they don't support this legislation as well. Yeah. There's almost nothing that a state is allowed to do in this space. That's been made clear by the U.S. Supreme Court. But there have been some creative ways that some states are trying to get around this. California is one that, have they pass their bill? They did pass their bill. Basically, it would be in employment cases, it wouldn't ban forced arbitration, but it would, what was it,
PAGAS is a private attorney general. So in a very limited circumstance, it allows you on behalf of the government to go and to sue the company for labor violations, and you get a piece of the violation, whatever the court says you should get, and then the state gets the rest. So it's not fully vindicating your rights, but you're vindicating rights on behalf of the state.
What is clear is if the entire contract is invalid, even if it includes a forced arbitration clause, they're supposed to throw it out. But the entire contract has to be invalid for that to be true. You cannot just go right after the arbitration clause. You're going to lose.
And a lot of state laws are preempted. So states have tried. We, Public Citizen, we litigated in 1996 a case on this where it was simply all the state said was the arbitration clause has to be on the front page, the first page. And the Supreme Court said, nope, that's a violation of the Federal Arbitration Act, preempted.
Okay. Thank you.
So we are at the home stretch. Just one point I wanted to mention before we kick it off to Ralph to wrap up is Senator Whitehouse made a really important point about the trajectory of when we've started to see companies really kick into high gear their corporate concentration of the Supreme Court, and that was Justice Lewis Powell's joining. And shortly thereafter, then we had it just snuck into a case where suddenly they said that there's a liberal policy towards arbitration. Don't know where that came from. And then about a decade after that, they started to really say that you basically can't do anything to protect yourself against arbitration clauses. And in fact, Justice O'Connor with then Justice Rehnquist dissented in that case, saying that the court was basically making up as they went along, that there was this was an edifice of their own making, which is a polite way of saying you're making this up as you go along.